All rise. Court is reconvened. You may be seated. Calling civil motion calendar add-on, civil number 11-11731, Dr. Orly Taitz Esquire versus Loretto Fuddy et al. For motion, reciprocal subpoena enforcement motion to hear in conjunction with the scheduled motion on 1/6/2012. Appearances, please.
Orly Taitz, plaintiff.
Morning, Your Honor. Jill Nagamine and Rebecca Quinn, Deputies Attorney General representing Defendants, Department of Health.
Ms. Taitz, you are to move on. Proceed with your arguments.
Your Honor, if I might get permission to sit. I arrived yesterday at 11, and that's when the first time I found the opposition from Ms. Nagamine, so I had to write my reply overnight. I will just have to read it because I did not have any opportunity to type it and present to you before the hearing, so I'm just going to provide my reply now.
You can argue your reply.
Plaintiff hearing, Dr. Orly Taitz Esquire is providing this reply to opposition to motion for reciprocal subpoena. I have 7 points, and is seeking first for this court to provide a reciprocal subpoena enforcement of a valid subpoena from the state of Georgia and extend the jurisdiction of the subpoena to Director of Health Fuddy. 2. Sanction the defendant's attorney, Deputy Attorney General Nagamine, for misrepresentation, defamation of plaintiff, harassment of plaintiff, attempted intimidation of plaintiff, and violation under color of authority of civil rights of the plaintiff and her clients by virtue of obstruction of justice and intimidation of civil rights of an attorney seeking legitimate redress of grievances. Argument number 1. Defendants are defrauding this court by stating that the subpoena is not valid. Subpoena at hand was issued in the state of Georgia, where the plaintiff as an attorney is representing multiple clients, voters, and presidential candidates. There are 3 attorneys representing plaintiffs. One of the attorneys is a duly elected state representative of the state of Georgia. Presiding judge is a deputy chief judge of the Administrative Court of the state of Georgia, Michael Malihi.
And Malihi is spelled M-A-L-I-H-I.
Yes, Your Honor.
Go ahead.
The trial is set for January 26, 2012. The case is Farrar, Roth, McLaren, Judy v. Obama.
And you need to spell that for the court report.
Farrar, F-A-R-R-A-R, Roth, R-O-T-H, McLaren, M-A-C-L-E-R-A-N, Judy, J-U-D-Y, and Obama, O-B-A-M-A. Plaintiffs are challenging Barack Obama as ineligible candidate due to a number of reasons. Among them, his lack of valid identification papers and lack of a valid birth certificate to prove that he is a natural-born citizen. Plaintiffs submitted to court multiple exhibits showing that, according to experts, Obama's alleged long-form birth certificate is a forgery. Nobody in the country ever saw the original birth certificate, since defendant Fuddy refuses to produce it for inspection.
And Fuddy, F-U-D-D-Y.
Yes. Thank you, Your Honor. Defendant Obama submitted a motion to dismiss in the underlying case in Georgia. Judge Malihi denied Obama's motion to dismiss. The parties are in discovery, and subpoenas are appropriate and proper. Rules of the Administrative Court of Georgia state 616-1-2-19. First, subpoenas may be issued which require the attendance and testimony of witnesses and the production of objects at depositions or hearings provided by these rules. 616-1-2-19. 2. Subpoenas shall be in writing and filed at least 5 days prior to the hearing or deposition at which a witness or document is sought, shall be served upon all parties, and shall identify the witnesses whose testimony sought or the objects sought to be produced. Every subpoena shall state the title of the action. 616-1-2-19. 5. A subpoena may be quashed by administrative law judge if it appears that the subpoena is unreasonable or oppressive, or that the objects sought are irrelevant, immaterial, or cumulative, and unnecessary to a party's preparation and presentation of its position, or that basic fairness dictates that subpoena should not be enforced. As such, the subpoena was issued timely. The form of subpoena is correct. Proper remedy for the defendants is a motion to quash the subpoena with the administrative judge in Georgia. It is axiomatic that subpoenas from out of state are given full faith and credit by courts in state. If a case would be going to trial in Hawaii, in Judge Nishimura's courtroom on June 26, 2012, and the witnesses and documents in question would have been located in Georgia, Judge Malihi or any other presiding judge around the country would consider Judge Nishimura to be a judge and a court of competent jurisdiction, and would extend the jurisdiction of her state court in Hawaii to the state of Georgia or any other state. While in 13 states in the Union, reciprocal subpoena enforcement is automatic, in the remaining states, including Hawaii, such enforcement is typically a ministerial duty which often does not even involve a judge and is freely given by the clerk of the court in order to extend jurisdiction, just as in federal courts, a clerk in one district would automatically sign a subpoena to extend the jurisdiction of another district. After the jurisdiction is extended through reciprocal enforcement, a party opposing the subpoena is supposed to file a motion to quash before the administrative judge. 2. Defendant's proper remedy is filing a proper motion to quash with the administrative judge. As stated previously, according to the rules of the Administrative Court of Georgia, Rule 16-1-2-19.5, a subpoena may be quashed, which is a proper remedy. The question is whether this subpoena was frivolous and whether it is likely to be quashed in such motion was to be filed. According to HRS 338-18-9, a person whose right to inspect or obtain a certified copy of the record is established by an order of a court of competent jurisdiction gives the plaintiff's right to access documents in question. Administrative Court of the State of Georgia is a court which deals with election disputes. This is not a small claims court or a traffic court. This is a court which is given a specific jurisdiction to resolve election disputes and challenges. Therefore, it is a court of competent jurisdiction. Defendant Barack Obama filed a motion to dismiss, which was denied. Defendant was ordered by Judge Malihi to stand trial and prove his eligibility to be on the ballot. In order to be on the ballot as a presidential candidate, one has to show that he is a natural-born citizen. A birth certificate requested is prima facie evidence of such eligibility. Best evidence rule dictate that the original need to be provided in lieu of the alleged copy provided by Mr. Obama to the public. If this court is refusing to allow the administrative court in Georgia access to the original document, then this court would be depriving a court of a sister state of admissible competent evidence necessary for trial and would be engaged in obstruction of justice. As stated previously, there are only a few instances when a subpoena can be quashed, which are as follows. A. Is the evidence requested irrelevant? No. When the natural-born citizen status is being decided, the original birth certificate is not irrelevant. B. Is it immaterial? No. Birth certificate is a material evidence needed to prove the place of birth. Is it cumulative? No, because it's the only thing that is requested. D. Is it unreasonable? No, it is not unreasonable to ask to inspect the birth certificate where the place of birth is being questioned. Is it oppressive? No. Mr. Obama has already released what he claims to be a copy of that birth certificate. In response to the legal action by Dr. Taitz, Obama's deputy campaign manager, statement that Obama campaign will sell more T-shirts and mugs with a picture of this birth certificate. If it is on T-shirts and mugs, how can it be considered oppressive to request to see the original document of what is on mugs and T-shirts all over the country? Taitz admits that it is oppressive to deny such subpoena. It is oppressive and a pinnacle of corruption for the defendant and for defendant's attorney, Ms. Nagamine, to refuse to cooperate and to demand sanctions and demand to deem Taitz a vexatious litigant for requesting a routine, mundane, reciprocal subpoena enforcement for trial, which is scheduled less than 2 weeks from now. As such, it is a valid subpoena from the court of competent jurisdiction. It does not fall within any of the enumerated instances where a subpoena can be quashed. There is no excuse or justification for this court not to extend the jurisdiction from the state court in Georgia and not to provide reciprocal subpoena enforcement with a leave of court for the defendant to file a proper motion to quash the subpoena with a trial judge in Georgia. 3. As an attorney representing plaintiffs in Georgia and in multiple other states around the country, Taitz is obligated to seek evidence necessary for trial and would be liable if she were not to seek evidence. As stated previously, Taitz is an attorney representing multiple clients around the country, including several candidates running for the U.S. president, members of the U.S. military, state representatives, and voters. As an attorney, she owes her clients a duty of zealous representation, and she can actually be liable if she does not fulfill such duty. There is nothing frivolous in her actions. On the other hand, it is frivolous and represents harassment, attempted intimidation of a civil rights attorney, and attempted violation of her First Amendment civil right for redress of grievances for Nagamine to demand that this court find that such a proper discovery less than 2 weeks before trial to be considered frivolous and sanctionable and vexatious. 4. This case is akin to Roe v. Wade. Just a few days ago, Ninth Circuit Court of Appeals issued a ruling in Barnett, B-A-R-N-E-T-T, Keyes, K-E-Y-E-S, et al., v. Obama et al., number 10-55084, where Taitz represented plaintiffs in a similar challenge filed on Inauguration Day in 2009. While the Ninth Circuit found that it was too late to file a challenge on Inauguration Day, it did find, however, that eligibility challenge can go forward and presidential candidates have standing to challenge eligibility of a candidate on the ballot. So the Ninth Circuit, whose decision is binding on this court, has already found that such election challenges filed all over the nation during the election are valid and candidates have standing. Moreover, multiple states around the nation have specific statutes whereby not only presidential candidates but also ordinary voters have standing to challenge eligibility of a candidate. Original birth certificate is at the root of every such challenge. In Roe v. Wade, Supreme Court of the United States has granted jurisdiction to a whole class of cases which are repeatedly brought to court and adjudication on the merits. As similar election challenges are mounted all over the nation, it is proper, in the interest of a judicial economy, to extend the jurisdiction of the court in Georgia, provide reciprocal subpoena enforcement, and have this matter heard on the merits, which would avoid litigation in multiple similar cases. 5. Taitz followed proper procedural guidelines. Subpoena in Georgia was issued when Taitz was prosecuting a related case, Taitz v. Fari. It was proper to seek such subpoena enforcement in the framework of a related case, and Taitz filed a proper motion seeking to have the subpoena heard last week during the scheduled hearing in Taitz v. Fari. As this court was not inclined to hear the subpoena motion on the same day and scheduled it for January 26, Taitz filed a proper motion to expedite, as the trial in Georgia is scheduled on the same day. The court expedited. Therefore, there is nothing frivolous procedurally. Until there is a final judgment in the case is open, and it is proper to hear motions in the case. Even if the final judgment is issued, in some cases, post-judgment 59E motions for reconsideration are filed. Or Taitz had an option to file a new case to seek reciprocal enforcement of an out-of-state subpoena. defendant did not show a shred of evidence of anything done by the plaintiff which is frivolous or sanctionable or vexatious. 6. In all her life, Taitz filed only one legal action in the state of Hawaii, which does not give rise for this court to deem her a vexatious plaintiff. Defendant and defendant's attorney know that the state of Hawaii would find a plaintiff vexatious in the state of Hawaii if the plaintiff files multiple legal actions in the state of Hawaii and those actions are found to be repeatedly frivolous. Taitz filed only one single legal action in the state of Hawaii under Local Freedom of Information Act, UIPA, seeking to examine an original document, and she filed one motion for reciprocal out-of-state subpoena enforcement to produce the same document. Clearly, one legal action filed in the state of Hawaii would not give rise to a determination of a vexatious plaintiff. Moreover, there is nothing frivolous in seeking to examine an original document in lieu of an alleged copy and in light of a proper and valid subpoena related to a trial which is coming less than 2 weeks from now. If this motion was frivolous, this court would have summarily denied the motion for reciprocal subpoena enforcement, as the court has inherent power to summarily deny frivolous motions, and would have not granted the motion to expedite. So it appears the defendants are de facto calling the actions of this very court to be frivolous, sanctionable, and vexatious. Clearly, this court sees that it cannot obstruct justice and deny courts of competent jurisdiction around the nation and deny access to admissible, competent evidence necessary for resolution of cases at trial. And the last point. Actions by the defendants and their attorney are frivolous, abusive, and oppressive, and represent a last-ditch attempt to obstruct justice, cover up forgery, and violate, under color of authority, civil rights of the plaintiff and American citizens. And the case was filed in August of last year, after the state denied Taitz to examine the original birth certificates of Barack Obama in lieu of an alleged certified copy, and refused to release a birth certificate of a deceased Virginia Sunahara, who was born on the same day, August 4, 61, and died August 5, 61, where there was a suspicion that Obama's forged birth certificate was manufactured via computer graphics using Sunahara's number. At the time, defendants used HRS 33818 as an excuse.
Excuse me?
Sorry. At the time, defendants used HRS 33818 as an excuse. Since then, Taitz filed with this court a valid subpoena from a court of competent jurisdiction in Georgia, which would allow her access to the document in question under 338-189. And the brother of the deceased Virginia Sunahara filed Sunahara v. Fari as the defendant, and the same attorney are wrongfully refusing to grant access, even though close relatives are entitled to such release under HRS 338-18-5 as a person having a common ancestor with the registrar. Both cases are before Your Honor. It shows to this court that the defendant's reliance on HRS 33818 is done improperly, and defendants are the ones who are flagrantly violating the same very rule they are relying on and refusing to allow inspection of the documents in question, even when there is an order from a court of competent jurisdiction and when there is a request by a close relative. It is abundantly clear that the actions by the defendants are frivolous, and the only reasonable explanation for such frivolous, abusive, and oppressive actions are a criminal cover-up. They know that the document in question is indeed a forgery, and that is why they are refusing inspection, even when obligated by the same very rules they are quoting. Not only defendants are engaged in obstruction of justice and cover-up, they are viciously attacking the plaintiff, defaming her, harassing her, intimidating her with demands of sanctions and vexatious determination. This is a matter of national importance, and it is the most sacred civil right of the U.S. citizens to right to vote in lawful elections, which are free from forgery and fraud. The right to vote is the highest form of the protected right to free speech, political speech. current case represents plaintiff's protected constitutional right for redress of grievances. This nation was built on such rights. When Susan B. Anthony fought for women's right to vote, state attorneys like Nagamini probably thought her actions frivolous and sanctionable. When civil rights attorneys sought to uphold civil rights of Japanese Americans during World War II in Korematsu v. U.S. and Ex parte Onda, state attorneys like Nagamini probably sought to deem civil rights attorneys to be vexatious plaintiffs. Today, Taitz is seeking Your Honor to grant her a reciprocal subpoena enforcement from a court of competent jurisdiction in order to represent her clients at trial in just 2 weeks and in order to uphold civil rights of every American to have lawful elections free of forgery and fraud, and is asking to grant her motion. Thank you, Your Honor.
Ms. Nagamini, your opposition.
Your Honor, actually, I think I pretty much stated it in writing, but I'll
Summarize it.
Summarize those 5 points that I made. First of all, subpoenas issued from a Georgia State Administrative Tribunal have no force or effect or validity in Hawaii. 338.18.9 does require an order from a court of competent jurisdiction. An administrative tribunal is not a court under this definition. Georgia does not have any long-arm reach to order a Hawaii government agency to do anything. The rule that Ms. Taitz was reading partially from also has a paragraph 4, which I stated in my opposition, that a subpoena may be served at any place within Georgia, and it goes on to talk about the conditions of that. Hawaii isn't Georgia. I don't believe Your Honor has any authority to enforce this Georgia administrative subpoena, and I think that I get that from Georgia law. My understanding of what I was able to find in Georgia law is that, and this is from the, let's get the site here, Georgia Code annotated section 50-13-13A7. Subpoenas shall be issued without discrimination between public and private parties. When a subpoena is disobeyed, any party may apply to the Superior Court of the county where the contested case is being heard for an order requiring obedience. So, assuming the Department of Health is disobeying something, which I would argue that it is not, because it has not gotten a validly issued or served subpoena, assuming we've disobeyed something, then the Superior Court in Georgia is the one who is supposed to make that determination. Even if that subpoena issued in Georgia was enough to, we were able to override those Georgia administrative rules, we still have Hawaii Revised Statutes 338.18. Ms. Taitz does not have, and her Georgia clients do not have, any direct and tangible interest in this record, and they are not entitled to see it, and they are not entitled to examine it or test it. Plaintiff has never even served the subpoena that she's talking about. Interestingly, the subpoena that was given to Your Honor to enforce has never been given to my clients. My clients got a different subpoena that was I've attached as Exhibit A to my opposition, and that subpoena was actually for something scheduled on for us to do the deposition on January 5th, which is passed, and for a court date which was January 16th through 18th. That's the subpoena we received, and I replied to that. You can see my letter response to Ms. Taitz at Exhibit B of my documents.
So in other words, Ms. Nagamini, with respect to the motion at hand, no service has been made as to the subject subpoena.
That is correct, Your Honor. It's predictable that if such a subpoena is served on my client that a similar response to all of the previous responses will go out. That is predictable because it's all going to come back down to 338.18, that Ms. Taitz does not have any entitlement to this record. Your Honor, as to my mention of sanctions, and this is not the motion for sanctions, that will be forthcoming in a separate document, but I wanted to mention that this morning so that Ms. Taitz can have all the notice that she might need when I do file my motion and she comes back here for that hearing. Monetary sanctions to cover all of the time that my office has spent on all of her requests. And that's a lot of time, Your Honor, because Ms. Taitz doesn't form her requests in a way that is easy to address. Her requests need some interpretation. And we do our best to interpret what she is trying to get and what she is trying to argue, and we have to respond to all of the arguments that we believe she's making, and that does take time. A lot of time has been spent on Ms. Taitz's issues in this very matter. So monetary sanctions will be something that we're asking for, and we are hoping that that can be something to reimburse our clients and ourselves for our time. But what we really will be asking for with all seriousness is that Ms. Taitz be declared a vexatious litigator here in the state of Hawaii. And there is precedent for this, in fact, for a circuit court judge ordering such a thing. In the case I cited, Eck v. Boggs, and there are criteria listed actually in our state law. We have a law for vexatious litigants, and I believe that Ms. Taitz amply meets all of the requirements. I listed 5 of the cases that she has proceeded in other jurisdictions and been rebuffed every time, including one that I mentioned in the state of Georgia by Judge Clay Land, a $20,000 sanction.
Ms. Taitz, just to advise you or apprise you that the court did allow you to read off your laptop. I'm not sure it was your laptop. Your entire argument, and I believe Ms. Nagamini neither objected nor interrupted you. So I do request the same courtesy. You can reply to her opposition.
I'm sorry, Your Honor. In other courts, they allow objections.
I know, but if you notice, Ms. Nagamini neither objected nor interrupted you.
Section 634J1 defines vexatious litigant, and I believe that Ms. Taitz and her actions here in the state of Hawaii and in this court satisfy all of the requirements of vexatious litigant. And I'm not going to go into that here because this motion isn't in front of Your Honor this morning. I would have prepared it for this morning, but I didn't have the opportunity to put together all of the list of itemized attorney's fees yet. I was responding to the subpoena enforcement motion, Your Honor, and I'm sorry that I couldn't have worked that out to save you a hearing, Your Honor, but there's been a pattern here by plaintiff, and it's disturbing and it's wasting time, and the money sanctions, maybe that'll stop her, maybe that won't. I'm thinking maybe it won't, because a $20,000 sanction in another case hasn't stopped her. So I know our attorney's fees won't be $20,000. So I don't have any anticipation that such a thing will actually stop her. It might help. But what I would like is for my office and my client to not to have to continue dealing with this. And I think because Ms. Taitz does meet the requirements of vexatious litigant, I think it would be very useful in the future for any of her filings to have to be screened by a court, for a court to be able to give an advanced determination as to whether there is any potential scintilla of merit to her claims. And so that's as I said, this isn't in front of Your Honor this morning. It's just kind of a notice so that nobody can claim that they're being surprised. And have I addressed all of Your Honor's questions in summary fashion about why there is no basis to grant this subpoena that wasn't ever served on my client? Is there more that I can address to Your Honor?
Ms. Taitz also raised the issue regarding, and she is correct in that there is really no judgment yet to date. Although the court did grant your motion for dismissal, that was an order granting your motion to dismiss. However, it has not been reduced either pursuant to Rule 54 or 58 to judgment, also the Jenkins case. So Ms. Taitz was right procedurally as to that aspect. So the court has not yet been in receipt of a judgment.
I've got a draft of it with me, Your Honor. And in fact, I have last week's order with me. Because of Rule 23, I had to present it to plaintiff. In fact, she hasn't had her 5 days with it yet. I believe I sent it to her on Monday and Tuesday. I don't recall. It was earlier this week. It has not been 5 days. I was going to ask if I'm assuming she's not going to actually want to sign it, and so after the 5 days I would be submitting it to the court anyway. If she has no objection to my taking a couple days off of that time, I'm actually prepared to hand last week's order to the court this morning, because there will be an order some way from today's hearing. I'm not able to give you that final entry of judgment pursuant to the Jenkins case yet, because one of the things that order requires be stated is that there are no pending matters in this case. And actually, well, today's hearing is a pending matter, and there is a pending matter of my motion for sanctions. So I am not going to be giving the court that order just yet.
Until such time it is appropriate.
Yes, Your Honor, but I am fully aware that I do need to do that order.
Okay. Ms. Nagamine has completed her argument.
Yes, Your Honor. I do have several points. First, as I stated, I would like, stated in my reply that I would like to file a motion for sanctions against Ms. Nagamine for public corruption and deprivation of civil rights under color of authority. And I would like to bring an example. If an individual gives somebody a forged check, a counterfeit check, and gets a house using a forged check, are you going to sanction the owner of the house who is coming to you with redress of grievances saying, my house was stolen by a thief, my house was stolen by somebody who used a forged check? It's inconceivable. And to me, this is just an unprecedented level of corruption that I see from Ms. Nagamine, where I presented here in court evidence that what Mr. Obama posted online is a forgery, computer-generated forgery. I showed you the layers, how it was created. I provided information. This is a forgery. Nobody in this nation saw the original document. My clients are presidential candidates. The case is going to trial in 2 weeks where this is being litigated. How in the world, in a democratic country, in a country that has any resemblance of any rule of law, seeking to verify the original document in light of forgery by people who have standing, that is coming in before a judge, can be considered frivolous? How could this be frivolous? How could this be vexatious or sanctionable? The office of the Attorney General of Hawaii has to be part of some kind of criminal enterprise to even think that this is in any way sanctionable or vexatious or frivolous. This is criminal. I mean, it's like a criminal enterprise running the office of the Attorney General of Hawaii. Going back to Marbury v. Madison, any rule, any act that is violative of Constitution, that is repugnant to Constitution, is void. The interpretation of Rule 338-18 by Ms. Nagamini is void. In general, there should have been a provision allowing to view such documents. But I have provided you with a subpoena from a court from competent jurisdiction. At this point, there is no excuse. There is zero excuse or justification not to provide such access, with, of course, leave for Ms. Nagamini to file a motion to quash the subpoena if she wishes to do so. If the document on file is not forged, it's over. If it's not forged, if it is forged, then she should be filing criminal charges against Ms. Fari or anybody else involved. How could it be considered that a proper part of the statute, if your Honor is checking, 338-9 states that a person who has an order from a court of competent jurisdiction is entitled to see documents. Your Honor, I'm here specifically to extend this order from a court of competent jurisdiction to the state of Hawaii. There is no sense of me serving any other subpoenas. Originally, the case was scheduled for January 18th. It was postponed to January 26th. In light of the fact that Ms. Nagamini stated that her clients will not comply for January 18th, it is pointless to serve yet again, as she stated she will not comply. The whole point of this hearing is a motion for reciprocal subpoena enforcement. I'm just asking your Honor to extend the jurisdiction to the state of Hawaii. Just as if you were to hold trial, a judge in Georgia would be giving you the same courtesy, just like it is reciprocal. If Ms. Nagamini gives me courtesy, which of course she didn't, but let's imagine for a moment, if she gives me courtesy, you would expect me to give her courtesy. If you hold trial and you want a witness from Georgia to appear before you and you issue subpoena, a proper procedure for me to go to a judge in Georgia and ask him for reciprocal subpoena enforcement, to extend subpoena from your court to be enforceable over a witness who is residing in Georgia. That's all I'm asking. This is a valid trial. This is a valid case. There is nothing frivolous. Your Honor, this is something that is done day in and day out. Thousands of subpoenas all over the nation are being enforced, are being extended by local judges or even clerks in different courts, including your courtroom, including this court. There is no reason not to give me such reciprocal subpoena enforcement, to extend it to the state of Hawaii. If not, then there is a standoff between this state, the state of Hawaii, and the rest of the nation. Because the plaintiffs all over the nation are filing such challenges. You cannot deny judge after judge after judge all over the nation their right to conduct trial with admissible evidence. For this court not to allow it, it would be an obstruction of justice. Not allowing a judge in Georgia or any other state to see admissible evidence. The copy was provided. All we're asking is to see the original for it to be shown at trial. This is a routine matter. If it would have been the birth certificate of Barack Obama, anybody else, it would have been routinely given probably by the clerk. I wouldn't be even standing in front of you, Your Honor. This is abusive and oppressive for Ms. Nagamini to seek sanctions against me. For what? What is one thing that is sanctionable? What is one thing that is frivolous that I have done? Nothing. I'm asking you to enforce a subpoena according to your own rules. It is sanctionable, oppressive, and abusive demand for sanctions that I've seen here coming from Ms. Nagamini and Office of the Attorney General of Hawaii. Your Honor, if this is not granted, it's not going to end here. It will go to higher courts. It will go to the Ninth Circuit. At any rate, there was never a case where in Ninth Circuit or any other circuit or the Supreme Court, a court found that one court, one state has a right to obstruct justice and deny all the courts around the nation a right to obtain evidence, admissible evidence. I'm not asking for anything that's illegal. I'm not asking for anything that's unethical. I'm asking for something that is routine. I'm asking, Your Honor, not to obstruct justice, not to be part of this criminal cover-up that we're seeing from Ms. Nagamini and Ms. Patriot. And all it is, I'm just asking, please, I'm asking this court not to obstruct justice and allow Judge Malihi or other judge to have access to evidence. If Ms. Nagamini is refusing to comply, she needs to file a motion to quash. This is a proper remedy in this case, Your Honor. Thank you.
Anything in response? Short reply.
I just have one point, Your Honor. Ms. Taitz just said that if this were any other birth certificate than the President's, we would have turned it over at once. That is inconsistent with what she herself said about the Virginia Sunahara birth certificate. The Department of Health isn't turning over the Virginia Sunahara birth certificate or John Doe or Jane Smith or any other vital record. We're protecting all of our vital records in addition to President Obama's vital record. It's all of our vital records, and that's the point that we're doing in all of these cases. 338.18 is about vital records. It has nothing to do with the eligibility of the President or any of the crusade that Ms. Taitz and her followers are after. This has to do with the confidentiality and the protection of vital records. I don't know that it's true that thousands of judges every day are enforcing other states' subpoenas. I'd like to see Ms. Taitz cite one example rather than claim that there are thousands of examples. I'd like to see one. But in this case, Georgia law is very clear that the place to enforce a Georgia subpoena is at the Georgia Superior Court level. It is not here in the Hawaii Circuit Court. Thank you, Your Honor.
Ms. Taitz has brought this motion pursuant to Hawaii Rules of Civil Procedure, Rule 45. That is the rule that she is citing to. Rule 45 specifically states, for attendance of witnesses form issuance, every subpoena shall be issued by the clerk of the Circuit Court of the Circuit in which the action is pending, not in which the action is pending in another jurisdiction. For reciprocal subpoena enforcement to be recognized, we need to have that particular language which would allow the reciprocal enforcement that Ms. Taitz is seeking. That language is not contained in Rule 45. Under Rule 45, it also references Rule 30 and Rule 31. Language also is not contained therein with respect to any reciprocal subpoena enforcement. Therefore, the motion is being denied. Ms. Nagamini, prepare the order.
Thank you, Your Honor. Would the court like the order from last Friday now?
I wasn't served with this.
Well, follow the proper protocol. I'm assuming under Rule 23.
Thank you, Your Honor.
All rise.